Yes. If it will not involve any of the parties to the suit. Any statement in authors anywhere can be brought. Yes, that was not the evidence that the document does not to prove a document by tendering a document. So let's look at the other rule of evidence. Evidence extracted from a witness in cross-examination, not pleaded. What is the value? And if it is for character, it does not need to be pleaded. If it is to prove the witness's character, it does not require pleading. Let me record you so we can have a reading. Yes, under section 232. Yes. A document can be used for the purpose of contradicting a witness. Notwithstanding that document was not front-loaded, can be used, and notwithstanding that the document is not tendered.
Why are we streaming on YouTube?
Yes, my lord. Also, yes. Mr. Kuti's objection is late. Mr. Kuti's objection is late. Witness has already acknowledged that he made the document. Acknowledged that he made the document. There has been ownership of the content of it. Okay, let's hear this. Yes, and the last point I was going to make, the requirement in the evidence is not limited to statements made intentionally. You cannot reach that conclusion without reading into section. Not say judicial. Yes, Mr. Davis.
Yes, my lord.
Your response to the objection. Your response to the objection.
Yes, my lord. I didn't really get. I scrambled a bit to get the objection, but my lord, my response is as follows, my lord. Under section 31 of the Evidence Act.
Section 31.
Section 31 of the Evidence Act and section my lord, section 232 of the Evidence Act. Under cross-examination,
Yes.
a document previously made to the witness can be put to him of testing his credibility, or otherwise.
Yes.
The document put to the witness
They are listening.
may then be considered under cross-examination. Yes, my lord, can you hear me?
I'm listening to you. I can't hear you.
As a call, please.
Yes.
I don't know what the lordship heard. So I said, my lord, that
What I've written is under
once
section
the witness has been
232.
confronted with that document,
Go on.
yes, my lord, once the witness has been confronted with that document, it can then be tendered through you. My lord, I rely on the case. Of one, I will spell it, my lord. WNWAN NWAN KWOANA Unwan Kuala versus FRN. (2018) (11 NWLR) part 1631. Part 1631, page 397.
Yes.
Yes, my lord.
What does he say?
That the objection is with due respect is totally misleading.
No, we need to know what the holding is. We don't have the law report here. So it is important that you let us know what the case, what the facts were, and what the holding of the court is.
As a copy.
Yes.
As a copy. My lord, I have a request. Wait,
Hold
how
on.
many times?
Authority. We need to know what it is about.
But because of this connection, I have one here. I can just read the same point so that we move on.
My lord is re-arguing, but I will allow.
Not re-arguing, it's just citing.
Go ahead. I will reply on law. Go ahead. Go ahead. Cite it and read it.
It is ECO, Supreme Court. ECO, AEKONG. That's what it's saying.
Quickly open.
And it is reported.
Quickly open it for me. Keko. States.
Yes.
At 2007.
Yes.
LTELR. Okay.
Yes.
42343 SC 42343. And it says section 2 that I just listed. My lord, at the no, I'm sorry, my lord. Section 232 of the Evidence Act intended to check double speak of prevarication shall make in the previous statement. There are essential requirements section and party cross-examination who intends to be the credibility of the witness by showing that what the witness is presently saying contradicts the writing. Attention specifically from those parts of the previous writing, which has been used for the purpose of that witness must be reminded. What he has stated, that has not been given an opportunity or making an explanation apparent from the authoritative stance of this course. Those are the templates. Those are the examiner shall intend any previous statement by witness and
yes. Now, what are the facts of that?
Absolutely.
And what was the issue that was taken to the Supreme Court? We need to understand that. You see, decisions don't stand in vacuum. Decisions are born out of the peculiar facts and circumstances of each case. So we need to understand what were the issues that arose in that case.
I say one important word that
no, hold on. We can't look at template without looking at the factual situation. We are dealing with seriously, we are dealing with a factual situation.
Yes.
And we need to understand what were the facts of that case. What was the issue? Because we are dealing with a situation here where there is a pleaded document.
Absolutely.
Where there are facts that were front-loaded. And you are reproducing a document that you did not even know when you cross-examined that this document existed.
Can I give a
The court is not aware, none of the parties is aware.
Explain Lordship's concern. One, this is a criminal case, so they were pleaded. That extent is
yeah.
Two,
they're not similar.
Similar in the sense that the document was not previously put in. Two, that a template means this is the guideline, the principle. Bring your facts. Yes, the template of the Supreme Court.
But you don't have.
I said, when you are confronted with this is what you do. Check A, check B, check C. This is what
absolutely. My Lord,
I have a case which was decided January this year.
My Lord,
if you look at Ndukwe and UBS, they went to town on following even their case.
Procedure.
And they set out the criteria for following a decision of any appellate court in your case. And the facts are that what is the template, like you said, using your word, that one, the facts must be similar or the same. The law applies to the same, and then the issues are the same, and then the law is not the same, and the issues are not interested in knowing the part of the issue.
Yes, to know, of course.
And this is because it is in
way section 232 operates. Documents
to understand what it is. And it is
saying something that is different from what it has. Which is why section says the document does not have it's a test of credibility. Whether he's lying or
so my Lord, at this point,
will it be to me when I sit down writing judgment?
Give him the opportunity to explain the contradiction. If he explains the contradiction satisfactorily, take a document back. He has deserved his credibility. If he cannot give a satisfactory explanation, then that document becomes relevant for the purpose of being tendered. Whether or not it was needed. So in any scenario,
my Lord, my friend cannot argue. There's no procedure. What he's doing, he has to commend an authority to the court. I have an objection. No. I have an objection. And allow you, my Lord. The Lordship has rightly identified the criteria. And when your Lordship referred to Ndukwe, I was almost going to jump on my feet to say Ndukwe is a recent decision, but even before Ndukwe, this actually started. By the Supreme Court, Oputa JSC in Adekoke Motors and Adesoya is recorded there. I think it's fact. There was a time when there was a confusion as to section 97 and 99 of sheriffs and civil procedure. There was a time when God had about 7 decisions. They were always going to the Supreme Court. And Ezomo Yakire, those line of cases in Calabi and Calabi. So Adekoke Motors. Supreme Court what's it? Oputa said it is a worrisome trend by lawyers. It's a worrisome trend by lawyers to commend authorities to the courts without relating the facts as to why that authority is relevant. I use this a lot anytime I'm replying or and that it's a declarable practice, a trend that lawyers should desist. My Lord, I'm coming. I must start with that. I'm coming. My Lord, asked a question. I couldn't answer. My Lord said, what is the fact of that case? 199 back there. I've used it in many criminal cases. 232. relates to two particular scenarios. And that is why I can stand there and tell my daughter, if I know these 100 cases along that line, 99 relates of these cases. Now, what happened is that the cases cited, what happened in the cases cited relates to a statement made by the accused. That is cited. When the lordship said, what is the fact? I will tell the fact of the case cited. An accused person was arraigned in court. The issue that went on was that he made a statement to the police, an extrajudicial statement. That extrajudicial statement was of those for which the commission was taken, that he didn't have an opportunity of being cross-examined on it. Now, 32 preserves everything made in a previous case. And this is the authority. Monoprix Nigeria Limited and Okenwa. 1995, 3 Nigerian Weekly Law Report.
Hold on.
So we should be reciting authority. We must relate it. Monoprix Nigeria Limited.
Point of law.
Yes, my lord. Okay, so Monoprix Nigeria Limited, Okenwa, 1995. M-O-N-O-R-I-X. P-R-I-X. Monoprix, mono, then P-R-I-X. Nigeria Limited. Versus Okenwa.
Okenwa.
O-K-E-N-W-A.
Okay, Okenwa.
1995. 3 Nigerian Weekly Law Report.
Yes.
Part 383. 325. Court of Appeal. And this is sorry, my lord. At the particular page I'm commending is at page 328. Held under section 199 and 209 of the Evidence Act 1990. Now section 232. Exact wording of that wording of the Evidence Act 2011. The use to which evidence given in a previous judicial proceeding can be put in latter proceeding is to cross-examine the witness as to impeach his or her credibility. My lord, judicial proceeding. That's what I'm coming to. My lord, the starting point of every adversarial proceeding, no surprise. You must give him the opportunity. That is, let me start with the philosophy. Give him, you don't come to court. Number 2. Okay. You can pick anything from anywhere and show him late in the day to say, oh, you wrote this at the point. The cases along those lines, they are usually either from previous judicial proceeding or any statement made to the police under that document that they make a statement. It's an extrajudicial statement. That's what the law says. But it is not a confessional statement yet until you get an opportunity of owning it or discounting it that, oh, I made it under certain condition, or it's also another. That is the meaning of that judicial proceeding. Now, what's the interesting thing? The learned author, ST On, anticipated this sort of argument, and I said that it is beautiful argument. I must comment. And you are only just being ambitious to extend the provision of the law. That just because it's that's what I was saying. The limitation enunciated by the Nigerian Court of Appeal, it's an authority I mentioned earlier on that. The cross-examination, it must be as to what is needed. So the fact that only the maker of the document and not a witness can be countenanced with the content. This is because the provision of 232 of the Evidence Act, not only the previous statement being made by witness, but of such being reduced in writing. The statement made being reduced in writing and subject matter of the previous proceeding. This is because the provision of if a person appears to this document as a witness, he will be taken to have read it. So there's even an additional the person must append the signature. Let me he comments that that's his opinion. That's not the law. It's just part of this and
Finish reading.
the person he will be taken to have read it before signing, and if he decides to collect from me any contrary construction of the provision of section 232 of the Evidence Act, while considering similar section 199 of the pillar, we work in justice as vital evidence would not have been properly brought before the court to assist the court in reaching a fair judgment.
Let me, Mr. Faso.
And then for that section, that paragraph. Previous statement, it is usually one used in a procedure, not otherwise you can bring anything, they can write something to them and say, oh, why not the one who wrote this at the point? It is sacrosanct, it's gone through a process of court. And my lord, and my learned friend said, oh, the counsel, the witness has assumed ownership. That's not the way that works. Assuming ownership relates to a document or any piece of evidence properly admitted. It doesn't matter what has been written on it. If I raise an objection that a piece of evidence has not been properly taken, it will be expunged. Because, my lord, the point is that a document is not before the court. At what point would the court be writing judgment and then refer to a document that was shown at a particular point in time, for which we didn't have an opportunity of contradiction through pleading? Sorry, my lord. I think the reference on this case is equally very important because he even refers to sufficient confrontation with his earlier testimony. I don't know how LinkedIn page can be said to be earlier testimony. And my lord, the case he referred to, I have the Nigerian Cleanup reports online, and your lordship can quickly scan through. The document, if that's the case he referred to. My starting point was to say, even the case he referred to does not avail. So this is the online report. Nigerian Cleanup.
The Kekong.
Kekong, yes, my lord. Yes, this is Kekong. Daniel Kekong versus States. Supreme Court judgment of 2017. Well, I apologize. I'm a bit quite eager. It's a small point that we've taken to the Supreme Court before. The popular case of Namai Pikin, we handled it for the defense. And one of the bases for which the conviction was at the High Court, at the Federal High Court, was one of them made a statement before the police. And that statement seemed to suggest that they did not carry proper pharmaceutical evaluation of producing the drug. So we took it all up that the issue, that statement made to the police, they never had an opportunity of confronting you. That the court cannot just assume any statement written for the police as having established. And it was that particular point that was upheld. That is an extrajudicial statement. In fact, that was where I learned it. Any statement made is an extrajudicial. That becomes a statement properly admitted in court.
I guess that is all that we need to have for now before I can write my will. Is there any other thing before I write my will?
No, I think I also understand. But there's no need to. let me just mention the point.
Oh.
Character evidence. Nobody will come to protect their character. What is character evidence? What is
Sorry, I better quickly just I thank you very much. Careful, this is parts that never comes back of the legal evidence before the court cannot be used or relied upon by a court of law to hold that it contradicts an existing legal evidence.
That's a different issue.
What is it? So contradicts and then there's
It's prejudice. Well, what I have said is this: I have heard the submissions of learned counsel for the parties on the use of the claimant's LinkedIn page for the purpose of cross-examination. Section 232 of the Evidence Act 2011 is clear and has received judicial pronouncement. The section provides that a witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relative to matters in question in the suit or proceedings, in which he is cross-examined without such writing being shown to him or being proved. The key words in my respectful view are, and I quote, relative to matters in question in the suit or proceeding. The question one may ask is the length of time the claimant worked with the first defendant in the issue in this case? I do not think so. The pleadings are clear on the issues joined between parties, and evidence is only required to prove issues joined by the parties. I have read the case of Keko and the state. Counsel, the facts and circumstances of that case are different from this. The statement in Kekon and the state was made in connection with that case. The LinkedIn page of the claimant was not written in connection with this case and has no bearing whatsoever with this. Reading through the cases, Section 232 of the Evidence Act 2011 has been applied to extrajudicial statements or statements made in previous proceedings. In this circumstance, I uphold the objection and expunge all evidence received in response to the question by the third defendant. Mr. Davis, are you still there?
As a couple, yes, my lord.
Do you have any other
Yes, my lord.
questions?
I will proceed.
Please, can you proceed?
Yes, my lord. Yes, my lord. Witness, I don't know if you have a copy of the T4.
Sir, I'm
Can you hear me?
having a hard time hearing you.
Can you hear me now?
Mr. Akuti, please tell Mr.
Is it better?
Sheikh to please let him cooperate with us so we can round up this.
Yes,
We're spending too much time on
Yes,
this.
I'm just
check.
having a. Yes.
Okay, please try and answer clearly, audibly, and just speak to.
No. I just
questions
didn't
asked.
understand. I
Can you
didn't
hear
hear
me?
his question.
Oh, okay,
Can you
you
hear
didn't
me?
understand.
I didn't hear his question.
Oh, okay. Please try and speak up.
Can you hear me now?
Yes.
Okay, yes. I said you recall you were shown exhibit C4. That's
What is
email
Exhibit C4?
Oh, this
email correspondences between
October.
you
Oh, yes, sir.
and the
Yes.
third defendant.
Okay.
Yes, I'm just going to ask you a few questions regarding that.
Okay.
The subject, do you confirm that the subject of that email, your email sent to the third defendant, was titled Improving Team Collaboration?
Are you asking me what was the subject of the email?
No, I'm asking you to confirm if that was the subject of the email.
I don't have the email in front of me, so I don't know. I can't answer that question.
Okay.
Can you open your system and access the email, Mr. Chief, please?
Yes.
Please, we'll give you a few minutes to open your email and
I
access
just
it.
need to make it quicker for you.
Okay, please, if you can, go ahead.
You know, Sheikh, that's the email that was read to you earlier on.
Yes.
That you confirmed. That is the one of October 30, 2019, and where to Mimi and the starting the opening paragraph. Unfortunately, since having joined Huber, I've been subjected to a repeated pattern.
Yes.
That's
Yes,
the
I know
email.
the email. Yeah,
Okay,
I know.
please go
But
ahead.
he was asking me what is the subject of the email, like the subject title. Like
Yes.
I don't know it because I don't have it in front of me, but I'm
You
sure
open
that
it.
you can read it.
Okay, you know, do you have your laptop there with you? If you can just open to it now.
And I'm opening my email right now. Which you sent me 3 bundles.
Yes, the
for
email
evidence,
you email which forms a trail. I mean, subject of a trail that's.
No, I understand. I'm asking you in which you send me 3 bundles of
page,
evidence.
the first bundle. Look at page 72. The first bundle.
Page 72. Okay, just give me a second.
That's the
Your
bundle that
counsel
contains.
referred to page 64, not 72.
Okay.
It's also on 72.
Page 64 is also on page 72.
Okay, just give me a second. It's just opening the document right now.
Page 64 or page 71 of the bond.
Okay, yes.
Page 64 or page 71.
Please go on, Mr. Davis. Ask him your questions.
Okay. You confirm that the subject of that email is improving team collaboration.
Sure. I mean, I can't find the email. I don't have it in front of me, but sure. It has to be something like that. I don't know why you would lie to me. So sure.
Okay. Yes. Affirmative.
Yes.
That's what it's.
Yes.
Also confirm to the court that the portion of that email headed "Here are my acts." The portion of that email titled "Here are my acts"
Yes.
was to ensure improving team collaboration, like you had said.
Yes. And among stopping the harassment, discrimination, and bullying. Yes.
After receipt of the said defendant's email, did you ever send any email to her regarding any complaint?
Did I send? Okay. I'm not sure I understand. Are you asking, did I send her follow-up emails
The said
after that?
the said defendant responded to your email.
Yes, she
Me
did.
responded to your email.
Yes, she responded to my email in which she was making fun of me and mocked me.
After a response to your email, did you send any other email to her regarding any form of complaint or any form of team collaboration improvement?
I'm sure I did.
You are sure you did? Thank you. Prior to working in Uber in Lagos, in Nigeria, had you been to Nigeria before then?
No, I have not.
Are you with me?
Yes, yes. I said, no, I have not.
Okay,
No, I have not.
okay, I heard you. I heard you. So therefore, it is safe to say that you would have needed assistance in trying to settle in Lagos.
No.
Since this was your first time coming to Lagos, coming to Nigeria.
Mr. Davis, I am not a child. I do not require assistance.
That's an answer to my question, please. Mr.
Okay,
Kuka, can you
so the straight up answer to your question is no, I did not
Mr.
require.
Apologies, man. Apologies, my lord. Apologies, my lord. Apologies, Mr. Davis.
Yes.
Check, please. Give your answer and speak to the question asked.
Okay. My apologies.
Without please.
My apologies.
You need to bring
My
yourself
apologies.
within. Okay.
My apologies. No, I did not require assistance in any shape or form, nor did I ask for any assistance in any shape, way, or form. Thank you.
Okay. So immediately you came into Nigeria or Lagos, you knew your way around Lagos and Nigeria.
I took the dispositions to learn the lay of the land as I would in any new country.
Okay. You took what? The disposition to what?
I took the dispositions to figure out the lay of the land as I would in any country.
Okay. Your accommodation or the tenancy agreement you executed. How did you contact the landlord?
I found the landlord myself and I contacted them and I executed the contract myself.
Fantastic. Thank you. You contacted the landlord yourself and executed the agreement yourself. Thank you. and I believe you pay the money directly to the landlord, or perhaps through the agent of the landlord, as the case may be.
Yes, one of the two. I can't confirm whether it was directly to the landlord or to the agency, but yes, I paid directly.
Okay. Thank you.
You're welcome.
Yes.
Witness, as at the time your employment was terminated, do you confirm that you were still under probation?
At which time exactly? My employment was terminated twice.
I can walk you through the document.
No. At which time exactly?
Go that way.
Sorry?
When your employment date was effective from when?
September 1st, 2019.
Thank you.
I believe.
And your probation period was meant to be for how many months?
I believe 6 months, I believe. I'm not sure.
6 months, correct. So I go back to my question based on the answers you have given. So you confirm that the termination of the employment occurred during your probation period?
Yeah. Yes.
Thank you.
Yes.
Just my lord, that will be all for the witness.
Thank you.
Thank you very much, Mr. David. My Lord, I have no questions.
My lord, I can't hear Mr. Kuti.
Okay. Well, I have no question to ask in re-examination. That's the case for the
claimants.
That's the case for the I don't know whether Mr. Armstrong will come back from that.
So, Mr. Quadrago,
Yes.
thank
my
you.
lord.
You can exit.
Okay.
Yes, thank you.
Okay. Thank you.